I now want to look at the distribution of assets. The distribution of assets by the liquidator. So the liquidator has been appointed. They have taken office. They have taken control of all the company's assets. They have been able to ascertain the liabilities of the company. All assets have been realized, so they are now applying these proceeds to settle the company's debt. Now, what priority do they follow in the distribution of such proceeds? Number one in that order is usually the costs of the winding up. The costs of the winding up are number one on the list, and these costs include the liquidator's remuneration. The liquidator's remuneration is top in that list, that any cost that this company incurred during the winding up process. They needed some agents to be appointed to assist them. Those agent fees are part of these costs. They advertised for these assets. Those advertising costs are part of the cost of the process. There are some fees that have been paid to the liquidator for the work they have done. All that goes into the cost of the liquidation. It is a priority payment that this company has to pay. The other claim that comes in are preferential debts or preferential claims. Preferential claims that exist, that stand against this company. Now, these preferential claims includes amounts that are payable to the NSSF as a result of member contributions, amounts payable to the NHIF as a result of employee contributions to the insurance fund, amounts owed to the revenue authorities by this company, amounts that exist as employee settlements. This is as a result of any court matters or court decisions that had been made, and employee salaries that are outstanding and have not been paid. They come in as a preferential claim to be settled before any other matters relating to this company are settled. Then once these preferential claims have been paid, we can pay the secured creditors. The secured creditors of the company can be paid. So these are creditors who have priority by the fact that they have been given some assets of the company as security. Then settlement can be made to the unsecured creditors. Then finally, we can have any surplus shared or distributed. Any surplus is shared or distributed to members. Any surplus is shared or distributed to the members. So that is the order of application. That is the order by which the proceeds that we shall realize as the liquidator, we shall be applying to the claims against this company. Release of the liquidator. That after the liquidator has concluded the liquidation process, they are expected to be released from the role as a liquidator. Whether the process was a member's voluntary winding up, a creditor's voluntary winding up, or ultimately the court's winding up process, once the liquidator has finalized their affairs as the liquidator. And we know so when we have an application being made to the court for release of the liquidator in a compulsory winding up, or the final meeting of members and creditors in the members' voluntary winding up, the liquidator is to be released from his obligations as he functioned as a liquidator. That if it is in the court's process, that we have a court winding up process, when the liquidator makes an application for release, if any person has any claims against the liquidator, say as a result of any offenses they committed or any rights that they violated in the functioning of a liquidator, then such claims can be made against the release of this liquidator at that point when the release application is being made. It is also worth mentioning some offenses relating to winding up. Offenses relating to winding up. Now, if you look at the winding up process, which is largely governed by statute, that is the Insolvency Act, there are some strict requirements of the Act that the persons participating in this winding up process, be they the directors of the company, be they the liquidators, that they must observe. That failure to observe such may result into criminal liability, for which the Act also prescribes punishment. Some of the notorious offenses that would be committed during the winding up process would be a false declaration of solvency. We could have a false declaration of solvency being made. That, if you do remember, in the members' voluntary winding up, since the company was solvent, the directors were to make a declaration, a statutory declaration as to the solvency of the company. That if this solvency was fictitious, if this solvency declared was erroneous, then the directors so declaring the solvency will be committing a crime. It is also a crime to do what we call fraudulent trading. This would be any actions by the directors of the company or any other company officer that are intended to defeat the claims of a creditor. It could be such a transaction such as disposing an asset which has been used as a security to a creditor, the intention being that creditor will be unable to recover. That transaction is fraudulent and the company officer responsible will be committing an offense. It is also possible that we have wrongful trading. We may also have wrongful trading, which refers to any actions by the company's directors whereby they increased the company's debt in circumstances where they knew or ought to have known that the company cannot avoid winding up. So we are looking at the directors and what they are doing. That they have done something whose effect is to increase the company's liabilities, to increase the company's debt in circumstances where we are saying they know or they ought to know that the company cannot avoid liquidation. So, dear learners, that brings us to the end of this topic and ultimately the end of our lesson. Just to recap what we have done so far, we have looked at the compulsory winding up, which is the winding up by the court. We have looked at who may possibly make a petition to the court to wind up our company. We have also looked at the basis, the grounds, the reasons why that petition will be made. We have also looked at the powers the court has while entertaining such petition. We have looked at the consequences of the court allowing or ordering the winding up, looked at the powers that the liquidators will be exercising, and we are urging you to make a particular distinction between the powers of the liquidator that require sanction of the court and the powers of the liquidator that do not require sanction of the court. We have looked at the distribution of the company assets, the particular order of priority. We have made a note of the importance of the liquidator being released. Then we have also mentioned the possible offenses that can be committed during the winding up process. I now want to refer you to the revision partner just to point out at some important questions that I think you should look at. We have a question here asking to distinguish between a creditor's voluntary winding up and a member's voluntary winding up of a company. There is a question asking candidates to discuss the various types of alternatives to corporate insolvency as provided for under the Companies Act. We have a question here asking you to explain the 6 effects of a winding up order. We have a question asking you to describe the legal effects of appointment of a receiver by the court in the case of a compulsory winding up. There's a question here asking you to describe the duties of the liquidator in conclusion of the winding up process. So there are many other questions that I would request you to look at in the revision partner just to help with your revision on this topic.